Okay, it's recording now.
Okay. Hi. So today we are presenting on Regents of the University of California versus Bakke and affirmative action. My name is Liz Fitznod.
My
Y'all
name
want to go over?
is Just Saunders.
I'm Maya Young. I'm Aaron Shedd.
Alan Bakke, a white California man who was unaccepted into the University of California twice, said he suffered reverse discrimination on the basis of race, which he argued was contrary to the Civil Rights Act of 1964 and the Equal Protection Clause of the United States Constitution 14th Amendment. With everything going on today in the United States, it is important to understand why people of color can no longer stand by quietly and continue to get treated wrongly. We were being discriminated against then, and we are being discriminated against now, and it needs to end. The Bakke decision of 1978 in concordance with affirmative action during this time portrays how a university attempted to compensate for racial injustices of the past by employing a racial quota program, but the program was deemed unconstitutional by the court. Affirmative action remained permissible, but quotas would not be allowed.
The affirmative action in the United States did very little to fix the problem of discrimination and underrepresentation in the workplace. Companies were required to have a certain quota of about 50% of spots to be filled by African Americans workers for in-house training programs. This was established in 1979 after United Steelworkers of America versus Weber. The affirmative action results in the lowering of normal standards to increase Black representation, which we found that from one of our articles. The statement represented that instead of fixing the actual problem, they were just patching the concerns as they popped up. The United States government and judicial system were not concerned with the discrimination and underrepresentation of minorities and women in the workplace. The concern of discrimination did not stay limited for long only with the workplace as minorities started to try and better themselves with an education. In the Bakke decision of 1978, Alan Bakke applied for the University of California's medical program and was rejected in 1973 and 1974. He later found out that some of the students who were admitted had scored lower on their benchmark exam and that had lower test grades than him. He found out that there was a special procedure for minority students. The minority students were only compared against other minority students. So because there were only 100 spots and 16 of those were for minority students. He then filed suit against the school and demanded that he be admitted into the program. And so the school then appealed to the Supreme Court to try to get it removed.
Yeah. So the aspects of affirmative action that were present in the Bakke decision, like Maya just said, the university set aside 16 of the 100 seats that were available for their medical school applicants for disadvantaged minorities. Applicants who fell under this classification were considered for all 100 seats, but the applicants who did not fall under this classification were only considered for the other 84 seats. So in a 1977 article on this court case that we found, Sedler discussed how the Supreme Court considered this to be a form of discrimination against whites, what might be called today reverse racism. And Justice Powell, the justice who swung the vote in this decision, stated that a racial quota can only be justified if it involves the eradication of proven discrimination within an institution. And we got that from an article by Edwards in 1979. Involved in the definition of affirmative action is the notion to end and correct the effects of previous discrimination. And in Bakke, the justices claimed that there was no previous discrimination by the university, so they weren't allowed to have a racial quota. However, many citizens of the US believe that the decision in Bakke did nothing to help those who were oppressed, and protests occurred across America to overturn the Bakke decision.
In conclusion, the concern of discrimination did not stay limited for long to only the workplace as minorities started to try and better themselves with an education. California state was unconstitutional in using racial preferences, but accepted in some cases by using affirmative action. This court case is all about affirmative action and demonstrates how complicated governmental actions can be. The Bakke decision of 1978, in concordance with affirmative action during this time, portrays how a university attempted to compensate for racial injustices of the past by employing a racial quota program. But the program was deemed unconstitutional by the court. Affirmative action remained permissible, but quotas would not be allowed. When you believe in something, fight for it. And when you see injustice, fight harder than you've ever fought before. A quote by Brad Meltzer.
All right.